So recently, you may have seen a 60 Minutes review where we saw the speculative lending industry was brought up through 60 Minutes. And many times when Leslie Stahl shows up at your door, you're thinking something's wrong and there's something bad that I've done or something like that. Well, I have to say that instead of things happening bad, some of these companies we're going to talk about actually used as seen on 60 Minutes. And as seen as part of the funding mechanism. And I was just kind of running through some different things here, and I looked up today the 60 Minutes article, and as I did, there were a couple of companies that, of course, that come in, they paid advertising beforehand. This one company called Sunrise Lawsuit Funding, the fastest growing lawsuit and legal funding company in 2020. Call Sunrise today. Sunrise Lawsuit Lending, easy application, no credit check. Oasis Financial. Need cash while your case settles? Apply in seconds and receive cash in 24 hours, once approved. Receive up to $100,000 risk-free from the nation's largest legal funding company. Credit score not a factor. Easy, Colonel. So what we're going to be talking about today is this growing phenomenon of litigation financing, speculative lending, and two areas that we look at, which is litigation loan agreements, as well as the actual litigation funding companies. To kick off our fundraising, excuse me.
There's going to be an ask.
We are at a special session, I will say. To kick off the speculative lending conversation today is a person who brought this issue to me and to many of you as well. Tim Nungesser is very well versed in this, and he is going to take us through the first part of it. So Tim, away you go.
Thank you, Representative. So Tim Nungesser, representing the National Federation of Independent Business. For those of you who know us, we represent about 10,000 small and independent businesses here in Florida. We are a nationwide organization, so we do have about 350,000 businesses nationwide, but I appreciate you sort of opening this up and starting the discussion on litigation financing. And I use the word litigation financing because this has gotten sort of several different names: litigation financing, lawsuit lending, speculative lawsuiting. All of it's sort of the same thing, but I'll kind of walk you through sort of what we're trying to tackle here. And this is something that impacts not just small businesses, but large businesses too. I will tell you on the litigation financing side, some of the lawsuits that we've looked at have been to the tunes of hundreds of millions of dollars. Some of these lawsuit lenders are paying in advance of a lawsuit upwards of $20, $30, $40 million in some of these cases. And when they spend that $20, $30, $40 million, they're going to expect something in the end. And so what we're finding is the money that they're getting in the end is pretty significant. So what are we talking about here? So when it comes to lawsuit lending and litigation financing, you have sort of the lawsuit lending side, which is sort of your personal injury cases. It's your Oasis Financials. It's some of the companies that Representative Overdorf just mentioned. And a lot of those are sort of the smaller dollar cases. So it's, he referenced one of the advertisements that said that, call right now, within seconds, we can approve you, within 24 hours, we can have $100,000 in your bank account. Those are typically your personal injury cases. And those are sort of mom and pop cases that can impact just about every business out there. And this is it's the wild, wild west. It's an industry that is completely unregulated in Florida, not just at the legislative level, but at the judiciary level as well. So these companies in Florida have the ability to essentially go out and take these lawsuits, package them up together. So they'll go out and take 100, 200, 300 lawsuits, package them up and sell them to a hedge fund. And that hedge fund will have the ability to create an investment product out of those lawsuits. So the reason we have the speculative lawsuit, the picture of Vegas in the background right now is this has often been called sort of gambling on outcomes. And the reason Vegas is important in this discussion is when you look at the strip, you look at Vegas, most of us have been to Vegas, you look at Vegas and you think, okay, I'm the person that goes and plays in the casino. Well, what these lawsuit lenders are is they are the casino. And what they're essentially doing is they are, you walk in, the dealer deals your cards. 45% of the time you're going to win. 55% of the time the house is going to win. Well, what's happening in these cases is on the front end, the lawsuit lender will know about the percentage of cases that they're going to win. And all they need to do is clear that 60%, 70%, 80% threshold, and they can make hundreds of millions of dollars. So I leave you with that reference just to understand kind of what we're looking at here. And, it's not just gambling on the individual cases, it's packaging them up and in the aggregate making money. Now, the second part of litigation financing is the larger companies. And so I know Representative Overdorf mentioned the 60 Minutes piece that ran back in December. One of the companies that was interviewed in that 60 Minutes piece, I believe the CEO was on talking, was a company called Burford Capital. And they largely do, and I'm going based on the reporting from 60 Minutes and the interview from the CEO, he largely does sort of business lending in this arena. And from his own words, he's successful about 90% of the time, meaning they shell out money, and 90% of the time he's expecting to win. And the 60 Minutes piece also went in and started talking about individual cases. There was a case of a farmer who engaged in litigation financing, was able to get about $4 million up front. On the back end, that farmer then had to pay the litigation finance company $8 million at the end of the suit. So in that case that was talked about on 60 Minutes, that litigation finance company made 100% profit. And again, CEO of Burford saying 90% of the time he's right. Think about just how much money that is that these companies are making. So Wild Wild West, it's completely unregulated. We're hopeful this year that the legislature can take a bite out of this industry and look at really sort of reining in some of these bad actors. There are a lot of practices in Florida that are unfortunately legal. And I'll run through just a couple of them, just because as you look at them, it reminds me of another industry that we all know very well, which is assignment of benefits. So one of the things that we are trying to prohibit is preventing the consumer's attorney from having an interest in the litigation finance company. Seems pretty basic. Unfortunately, that is legal in the state of Florida. And I know we saw with assignment of benefits, as we started digging into some of the companies that were some of the bad actors in South Florida, in Miami-Dade and Broward, potentially there were cases where, there were attorneys and roofers that, potentially had sort of money in different companies and that sort of thing. So some of the other things we'd like to see happen would be the prohibition on packaging these cases up and selling them. Seems like kind of a no-brainer. As I mentioned, you've got these litigation funders that are, throwing these things together, sending them up to New York, and getting, wealthy investors to invest in the outcome of the lawsuits. It seems like a no-brainer to prohibit the assignment of these lawsuits. If a litigation financer wants to come into a case and they think the case has merit, they should see the case through to the end. These cases aren't going on for 20 years. It's not like a mortgage where you have, you're signing on to a 30-year note where the mortgage company needs to be able to get out of that mortgage for whatever reason 5 years down the road or 10 years down the road. These aren't that long of cases. So we are hopeful that the legislature will tackle some of these issues moving forward. But I'm prepared to talk about quite a bit more, but I feel like I could take up the whole segment. So I'll kind of leave it there with the legislative side.
Well, thank you very much. Appreciate it, Tim. And I'm going to turn it right over to Jason. Jason's going to give us a little different perspective on what's happening here. So without further ado, Jason Gonzalez.
Thank you. So my role and my law partner, Amber Nunnally at the Lawson law firm, we have a more narrow focus on the judicial side to try to curtail the abuses in third-party litigation financing, where the legislature is the proper forum to address the substantive legal changes, adding regulations or even banning some of these practices. Over on the judicial side, the courts do not have a proper role in changing substantive law, but they do have a role in changing procedural law. And this is something that's often forgotten. And many of you focus on the legislative process. Keep in mind that there's some things our courts can do, the Supreme Court in particular, because they control the Florida Rules of Civil Procedure. And under the Rules of Judicial Administration, you can petition the court to change the rules of civil procedure. And sometimes some of these procedural changes can have is important effect on curtailing some of these lawsuit abuses as what you get in the legislature, which are critically important and things that the courts can't do. So what we've been working on, and we're very close to filing a petition with the Supreme Court, asking them to adopt civil procedure rule changes that will require some transparency and some disclosure. And you can imagine the impact of that when a judge and a jury are aware that this is going on, who's behind it, and what the terms are of what they're involved in. It's enlightening to the jury when they hear that. And there's some very good reasons why it's critically important. Disclosure is warranted because some of these companies are publicly traded. So you could have a judge or jurors that don't even realize they've invested in these companies without the rule requirements for that kind of disclosure. They may be unknowingly and may find out at some point that they've been involved. Another problem is the possible ethical violations of the sharing of fees between lawyers and non-lawyers. That's prohibited right now in the rules, and without these arrangements do create a risk that these companies are having fees shared by lawyers, attorneys' fees. So that's another reason for more disclosure, so there's a light shined on it. There are conflict of interest issues. The funders paying lawyers creates a conflict for the lawyer who may be more loyal to the person paying them. Yeah, you probably can't imagine that the plaintiff's attorneys would be more loyal to the person paying them than their actual client that they're supposed to be representing, but that actually can happen. And then there's judicial conflicts that arise when there's not disclosure, because the judges, they may have some interest that they're not aware of. So there's lots of reasons for these transparency disclosure requirements and rule changes, and it's already been done in some other jurisdictions. The Southern District of California already has a disclosure requirement in federal court. New Jersey District Court has put in requirements, and there are 3 other states that have also put in disclosure requirements. So I'd encourage you, even outside of this context, any of you in the process, you have an important issue, a lawsuit abuse issue for a particular industry, for your association, start thinking outside the box about whether there's something that could be done in the rules of civil procedure. So you could support your client, your industry on another battlefront, and we could help develop a rule change. As we worked 20 years to get our courts in the shape that they're in now, it's time for us to take advantage of the fact that we have this incredible majority on the Florida Supreme Court and our district courts of appeal. And you saw what they did on their own, taking up the Daubert standard and adopting that by rule change, and then also with the federal summary judgment standard. So we need to be, in this context and other contexts, not leaving that part out of it. We need to be going to the Supreme Court and petitioning. It's not a situation where you need a test case, an active test case to work its way up. We go straight to the Supreme Court. We petition them, they begin a process, and then they invite interested parties to come in and provide briefing. And that's where all of your organizations, your clients, would then have opportunities to come in behind us with additional briefing, and then we make arguments to the court and ask them to make the changes. So for litigation finance, this will shine a light on what's going on, and it's gonna help complement what Tim and others are doing on the legislative front.
So to kind of bring it all together, obviously, if we're out there and say I'm in a real need for a car, and I just got to have a car, and I go to my good friend Tom Fabrizio, and he says, "Oh yeah, I got this car here. Sign right here, no problem." And I'm finally, I can take my family back to work. I can do all that kind of stuff. And then as I go along with the car, Tom says, "Oh well, by the way, the interest rate. Yeah, we haven't really decided on that. We signed here, but the interest rate actually it's at 45%." Oh, and it compounds monthly, by the way. And so now I'm like, I got to sell this car. I have to actually sell this car. So I go and try to sell the car, and as I go through it, I have to now disclose the fact that I'm going to be selling this car, possibly. Or maybe I don't disclose that I have all these terms associated with it. So now I have to sell this, say, he gave me a nice little Honda Accord, say 2019, and somehow I have to sell this now for $150,000 in order to pay off my loan. It sounds ridiculous, but that's what we're doing. And what sounds ridiculous on this is that these interest rates, there's no cap on the interest rates whatsoever. Also, you look at the folks that are lending, a lot of the lending people that are out there, there's no requirement for them. There's no bonding requirement, there's no residency requirement, there's nothing associated with it whatsoever. That's just on the private side and the simple plaintiff side. We're not talking about the overall financing side here for larger cases. So this is what we're looking at, and then what does that do? Ultimately, as you all know, just drives up the verdict and drives it up to a point where it's not achievable, or they don't settle until a time when it's now just an absolutely ridiculous verdict. So that's what we're looking at. Or in the case of our farmer from the Midwest, you now have a case where they settle for $4 million, but they end up owing $4 million on top of that as well. So that's what we're trying to attack here now in the state of Florida, and hopefully we'll be a little bit successful this year, chip away at it. And just wanted to know if there's any questions out there.
I have one, if you don't mind. How many, do you have a grasp on how many lawsuits, like a percentage-wise, are being funded through these speculative lending practices?
After we get my rule change in, we'll get back to you and have an answer to that. But that's part of the problem. We know it's a $17 billion industry. We just don't know exactly where the problems are. And one other point I'd add that these companies are doing. We have 1,014 state court judges in this state. 940 of them are trial court judges. And as you know, Brewster, the plaintiffs' bar for many years has been recruiting they'll have their junior partners or senior associates run to be a trial court judge. Even when we had good governors trying to appoint the right people, they would go around that with a judicial election. And now they know right where those judges are. So they can go to the casino and bet on the claims that have been assigned to their judges. And it sounds a little crass, but these judges are not all equal, and some of them definitely have a plaintiff's bias, as you know, and you can see it right from the industry, the profession they came out of. So that is a serious problem. It's augmented by this, is they know where to bet on the claims, and those judges will help force a settlement for more than what it should be.
Tim, any idea?
Yeah, I think Jason hit the nail on the head, but I think once we get the disclosure piece, I think we'll start learning, how many of these cases are out there. I mean, and I'm not an attorney, so I will not represent myself as an attorney, but in talking to some smart attorneys in this area, these contracts are discoverable, but you have to know to ask for it, and that's sort of part of the problem right now is to make them to allow them to be turned over when the case is filed, when the lawsuit lending contract is executed. Get those turned over automatically is the key, because a lot of attorneys just don't know to ask for them.
And we haven't registered any of these lending companies yet either in the state of Florida. So we really don't know how many of them out there, how many of them are, Joey on the corner who's lending the money versus a reputable institution. Any other questions out there? Thank you all very much.